special privilege, and I as the dean have a special privilege of bringing one of our own to our community to talk about their scholarly research. And I am blessed to have so many wonderful faculty members to give riveting talks. And this year we have one of ours standing next to me. For those of you I've not met, my name is Phil Weiser, and I am the dean here at Colorado Law. Thank you so much for joining us. The Scott Lecture was established in honor of Austin Scott. And maybe there are a few alums here who had the pleasure of learning from him. He was renowned for his wit and wisdom. And every year we have this lecture in his honor. This year, Professor Amy Schmitz is here to talk about her work involving consumers and some of the research she's conducted recently. As those of you who know Amy, and many of our colleagues are here today, we know and appreciate the care, intensity, and passion behind her work. This is a sustained body of work that has not only a deep scholarly stream, but also relevance in our community. She's taught classes that have focused on people doing real outreach focused on consumers. She's developed a website, consumer.info. She even developed a song.
And film.
And film. So without me take up any more of your time, let me introduce our own Professor Amy Schmitz.
Oh, thanks. Well, first and foremost, I just wanted to give my sincere thank you. Thank you to the dean, and certainly for inviting me to give this talk. And moreover, to all those folks, Doris and the rest of the people with the IT department, and Diana in the Faculty Assistance Office, and all those who are part of the CU team, Jane, all of our library staff who have been so tremendous in my research over time, and when I ask for sort of goofy things from other libraries near and afar, and all of my students who are upstairs, I think, at a happy hour, but to thank them as well for the insights and working on different outreach projects, and friends of mine who are here in the audience as well, who inspire my interest in consumer rights, and I'm constantly asking them questions, and it really helps me to inspire my research and work. But first, of course, before I begin, I'd like to sort of start with a cheap gimmick. I was going to try a joke, but as my students say, Professor Schmitz, you're not funny. Therefore, I will leave it to the professionals.
No, Mom's gonna do the turkey. Yeah, Dad wants ambrosia, so I guess we gotta get those miniature marshmallows. And I'll do the crescent rolls, and you do the cranberries. You know I can't cook.
I don't understand. I made a reservation. Do you have my reservation?
Yes, we do. Unfortunately, we ran out of cars.
Double Bacon cheeseburger. It's for a cop.
What's that all about? You gonna spin it now?
No, I was just telling him that so he makes it good.
But the reservation keeps the car here. That's why you have the reservation.
I know why we have reservations.
I don't think you do. If you did, I'd have a car.
Don't spit in that cop's burger.
Yeah, thanks.
Roger, I'll leave it there.
Yeah, well, I'll see you tomorrow then. Gobble, gobble. Oh, bye-bye.
Give me a liter of cola.
A what?
A liter of cola.
Liter of cola? Do we make liter of cola?
Will you just order a large farva?
I don't want a large farva. I want a liter of cola.
I don't know what that is.
Liter is French for give me some cola before I break loose and let me.
All right, relax.
Okay, I believe you have to fill out a form for that.
No, I'd like my money back now.
I'm sorry, it doesn't work that way. You see, I have to fill out a form and, well, you ate most of it already, so...
I'm sorry. We stopped serving breakfast, but we are on the lunch menu now.
But I want breakfast.
Well, you can't have it. We're not serving it.
Mister, if you don't shut up, I'm gonna kick 100% of your...
Is there a problem here? Hi, I'd like some breakfast. We stopped serving breakfast.
See, you know how to take the reservation, you just don't know how to hold the reservation. And that's really the most important part of the reservation, the holding. Anybody can just take them.
Now, we can all laugh at that, right? You had that feeling before, sort of been in line, you've been on hold, you've been trying to get some sort of a remedy on a consumer purchase. You feel like, well, are things getting worse? I feel like they're tightening the remedies. Is there any such thing as customer service anymore? Now, you can say that's comedic, right? We can sort of laugh at that, but it's also concerning. It's concerning because there are many repercussions on the market, on contracting, on our rights. And are they getting tighter? Yeah, research actually shows that they are. Now, we may think there are a lot of Jerry Seinfelds out there, a lot of squeaky wheels who are getting the grease. Now, we hear about the old adage, the squeaky wheel gets the grease, but the truth is there are not as many squeaky wheels as you think. It worked about 10 minutes ago. I know, right? I'm not squeaky enough, I guess. What's going on? Okay, thank you. All right, so first of all, the research shows that about 1/3 of consumers that are even aware of their rights, that are even aware of the deals that are out there to be had, will do anything. Make a phone call, write a letter, write an email. Will do anything. Those are not the squeaky wheels who actually get remedies. In fact, you have to go the extra mile. And it's very few of those consumers, a very small handful, that actually do obtain remedies on their purchase problems when it comes to consumer contracts. The vast majority, most individuals, are not getting remedies on contract complaints, getting changes to form consumer terms. We're talking about consumer purchases, okay? Products and services that we buy for our family and household. We can argue, okay, well, that's fine, because those who are exerting their resources are being responsible enough that they should get those remedies. But it's widening the gap between the consumer haves and the have-nots. In other words, those that already have more resources, that are already more educated, that are in higher socioeconomic status levels, are those most likely to get more remedies, versus those with less resources are getting less remedies. And it starts at the very inception of who actually squeaks. Another study showed that for every 1,000 purchases, in the highest earning categories, about 98.9 or 99 of those individuals are going to voice complaints, versus 60.7 purchases in the lower status. It's widening that gap between consumer haves and consumer have-nots. It's almost a consumer caste system. Now, I didn't go out sort of assuming this. This is just the research that plays out, especially when you look at economic and marketing literature and you go outside of the law school and find out some of the sort of nitty-gritty of what's going on. This is what I call the squeaky wheel system. Now, right now, I can't fully go into this, but there's different forces at play. And when you look at it from a broad base, right, so you're looking at the psychological data, the behavioral data, the economic data, and the legal, and you put it together, there are a few reasons why, first of all, why are there so few that are in the very tip of that iceberg that are squeaking, that are complaining, that are going the extra mile? Inertia. What do I mean by that? Contracting inertia. There is research out there, especially in the behavioral law and economics field, that there is contracting inertia. Example, form contracts. We aren't going to sort of go that extra mile. Anything that requires pro-action is difficult. Inertia, it's a simple way of saying we're lazy. I'm lazy, I'm as lazy as the rest. I mean, it's difficult to sort of that pro-action to actually ask for, seek a remedy to squeak. Over-optimism, the kumbaya phase of contracting, as I like to call it. You go in with a purchase, you made that purchase. You're expecting the best, otherwise you wouldn't have bought it. Confirmation bias goes along with that. You don't want to have a complaint because you want to confirm that I made a good purchasing decision. We all sort of have egos, right? And so we don't want to say, well, I was stupid, I made a bad. You want to sort of assume that it's going to work out fine. And that's another reason why oftentimes we don't complain, thinking, well, it's my own darn fault. Rule following. We tend to be rule followers. This is the signaling power of form contracts, for example. You want to follow through with your purchases. You want to follow through with the terms of a contract. They have shown, actually, there's been simulation studies where it is more powerful to give a moral threat. In other words, if you tell somebody, oh, you'll be a bad person if you don't follow through with this, versus I'll sue you, it's actually scarier, the moral threat, than I will sue you. This isn't rocket science. Who's got time and who has patience? I don't. I don't know about you, but when I'm put on hold after a certain point of time, I do a cost-benefit ratio in my head, and honestly, I think I'm quite rational to hang up and move ahead. Because we don't have enough resource and patience oftentimes to go the extra mile to get a remedy on a product complaint or whatever it might be. Socialization and biases. And this is really hard to detect, and it's a difficult field in the sense of, first of all, we can be socialized to not complain. I know that I was brought up in the Midwest. It was kind of this buck up and deal with it, right? You don't complain about things, you just sort of deal with it. You're socialized not to complain. Also, this tends to be more true for women than men, in terms of sort of nice girls don't do that sort of thing. And I'm not saying this is true for all women or all men, but it's just, that is the research, that women are less likely to seek their, or to seek contract changes or whatever it might be. Biases. This happens. Even subconsciously, even when you control for other factors. Customer service representatives are people too. They have their own conscious and subconscious biases toward different customers and clients. And people are treated differently, even when they're seeking the same sort of contracts or purchases or remedies. Now, on the flip side, so you have fewer consumers squeaking, but you also have companies where there's an impetus to grease the squeaky wheels. In one of the articles I was reading, it said out, those squeaky wheels are worth a lot of grease. There's a lot of reasons for that. First of all, rationed remedies. Especially in the economic downturn, companies now have less remedies to give. Insurance companies talk about this sort of without unabashedly rationing by hassle. It's in the idea that, well, it's good for all of us. It's good for all insureds because we can lower the rates, we can offer better rates to everyone if we only give out money to those that are very persistent in seeking money on their claims. That's not actually illegal unless they act in bad faith, or we can show something greater than, you do have to sort of be that squeaky wheel. Rationed remedies. Retained customers. When you're rationing those remedies, you want to retain the customers you believe are going to be most lucrative. those tend to be the most, again, with the most resources. If you got more money, you're going to spend more money. Those are the clients you're going to want to seek, right? So you're going to want to grease those wheels. And by the way, when I talk about the squeaky wheel system, you can also, there's such a thing as being too squeaky. You got to know how to squeak. In other words, when I'm talking about the sophisticated consumers, the individuals who actually know the language, they know how to assert themselves well, those are the people that are getting the remedies, all right? And they often tend to be those that have the sort of highest consumer status, different reasons why they might be very much worth the grease. You want to make them happy. Also, the research shows it is 4 times harder to get new customers than to retain the old. So you don't want people to leave, and if they are going to squeak, if they are going to complain, you want to give them a remedy and keep them on board, because that's probably going to be worth your time and money. Think loyalty discounts. Ask for that next time you call DirecTV. Quieted claims. Along with that, you want to grease the squeaky wheels, because then those are the same proactive individual who has the resources to actually assert themselves, to write a good letter, to follow up with whatever you need to do in order to get a remedy, also would be the same type of person who is sufficiently proactive to go on social media sites and launch an awfully nice campaign against you on Facebook, for example. You want to quiet those claims. And you really don't want that individual to bring a class action or to to alert other people about this or to sue you. I mean, there's a lot of reasons why it is very worthwhile for a company to grease those wheels. Who squeaks? Well, we have concerning consequences from that. Again, you go back to, well, this is just business. And it's just a matter of, good economics, and everybody is sort of, if you want to be that responsible consumer. But there are concerning consequences on the market, and at a greater extent. The first two go together. Stifled informed minority and stymied market regulation. Classical contract theory and law and economics teaches that we will be rational actors with perfect information who will go out and negotiate for the best contracts. We will vote with our feet. In other words, that if all of these rational actors are finding the best products, the best services, reading our contracts and acting appropriately, then through competition, their companies are going to have to rise to the level of the best of what we want, of what consumers want. Well, that sort of doesn't work because of the sort of perfect information, right? Because we know it's been proven time and again that we as consumers do not read their form contracts. We're not reading those contracts. So then the next argument is, well, you don't need that. All you need is this informed minority. At least there will be a minority, a sufficient number of individuals who will go out, read contracts, squeak, complain when there's something wrong with a product. And that individual will inform the rest of the majority. And then competition can do and the market can regulate itself. Well, with the squeaky wheel system, and if individuals are being sort of quieted, then that informed minority is not informing anybody. And what's the incentive to really share rationed remedies with others? Especially when some companies will say, well, because you're an extra good customer, we'll do this for you. Are you going to really want to go out and sort of share this with the rest of the world? Not necessarily, probably not. Under enforcement of consumer protections. Here's where this converges with things like arbitration clauses. Now, there are arbitration clauses in nearly all, you see them in your cell phone, in your credit card contracts. I did an empirical study myself just looking at cell phone and credit card contracts. And indeed, you just see these arbitration clauses everywhere. Arbitration clauses are important because they cut off your right to join class actions. And they keep your claims out of court. Now, most consumers are not aware. When I held focus groups in Denver, and also, as we'll see in my e-survey, people don't really realize the importance of an arbitration clause or what it might do with respect to enforcing your rights or getting out this sort of public enforcement of consumer protections through class actions. So what's happening is an under-enforcement of consumer protections. Contractual discrimination. Again, as I talked about before, we're seeing different individuals being treated differently. And how this combines with the next. And this is new research that I'm doing right now and sort of looking at the importance of big data now and what they call consumer scores and how that plays in with how you get treated as a consumer and if you might be offered a different deal, depending on your socioeconomic status or what they assume. These numbers sort of fly under the radar of the Fair Credit Reporting Act. Now, right now, the FCC and others are looking into that. So that we'll find out more, and hopefully that will be in the next iteration of my research. So who squeaks? Again, 58% of those earning over $50,000 versus 43% of those earning less said that they will bargain at all. My own survey, 71.3% of the female respondents versus 53.4% of the male respondents said that they rarely or never try to negotiate contract terms in consumer purchases. Now, what happens when we control for things like your financial status, all other things being equal? This is a very interesting study. In this study in Chicago, Professor Ayers, what he did is he sent individuals out of all different car dealerships in the Chicago area, wearing essentially the same outfits, having kind of the same script, the same sort of bottom line as far as their financials. And this shows how customer service comes in and biases. The white female consumers ended up paying 40% higher prices than the white male consumers. The black consumers paid 2 times greater markup than all the rest. Okay, that's just car salesmen, right? We're just talking car sales in Chicago, I mean, right? You could just assume. No, another study, more recently, 2006, study by the Consumer Federation America found in the subprime markets. Upper income black women were 5 times more likely to end up with a subprime loan than the same level of income white men. Not surprisingly, the researchers asked, why? Why would people who qualify for prime mortgages end up with subprime mortgages? They're being steered maybe toward that? Different assumptions come into play. Is this just benign business? The business people will say, well, it's not in the seller's best interest to charge one price. Whatever the market will bear is a fair price, right? So if there's individuals who will pay more, great, they should go for it. Well, that is problematic. So I'm going to give you also a glimpse. Now let's add to that picture, okay? So we started out with that, and we're looking at the picture of sort of other people's research. So I said, well, I kind of want to look at this myself, and I want to do some research on consumer contracting. And beginning in year 2007, I was working with the Institute for Behavioral Sciences. We did focus groups. We crafted an e-survey and put that together and sent it out to Colorado consumers. And what I'm going to share with you is a very small slice of the data, and using only rounded numbers here for ease of the pie charts and to make it more visually appealing. But you can access more of that in the appendices and different articles that have sort of come out over time, because there are lots of different areas to this survey. But what I want to do is just focus on the questions and the data that sort of goes into the squeaky wheel system and into contracting, and why things might be going awry when it comes to consumer complaints. First of all, when consumers were asked, already, we know they're not reading the contracts, and that did play out in my own survey as well. So these are kind of perceptions about different terms in consumer contracts, okay? And they were asked generally, and generally using your own sense of fairness. How fair do you view, and then there were all different terms that we kind of put out in different questions, in consumer products. How fair do you think about them? Warranties got the highest rating. Consumers said completely or usually fair, 62% for warranties. Second highest was the company standard form contract. You have at least a majority not reading contracts, but assuming they're usually or completely fair in these different areas on consumer products and services. Now this one's kind of funny, because we have a majority there trusting the companies, right? Not so much with friends and family. Here we've got 41% saying usually completely fair, but we've got, you know, of course, how do you explain that? Because you go to the next, and remember we were talking about the subprime market, and we were looking at the car sales. Higher percentage are saying usually or completely fair versus our friends and family. But what was most interesting is when it comes to remedies. Lowest billing, the two types of terms that were seen as the least fair, and there were lots of them in between sort of that, but you don't, this is for our purposes, let's just focus here. The very lowest, dispute and settlement agreements, but the very lowest was gym memberships. But there's in terms of usually or completely fair, we're pretty skeptical of what we'll even get if we squeak. Also, are we going back to even look at the terms? How important are the terms in the contract when you do have a product complaint? This is interesting, and the reason I highlighted the no's is because what they're saying, what consumers are saying, is contract terms become largely irrelevant when we have product and service problems as consumers. And what I personally found especially interesting was how much they said no. 88.6% said no with respect to arbitration clauses. Now, if you recall, what did I say earlier? Well, actually, it turns out that arbitration clauses are very important if you have a dispute or a claim on your contract. Because you're probably going to have to use that term, arbitration, because you can't go to court. How often do you try to change contracts or negotiate? Again, that inertia. Is it true? Is this true about individuals? Yeah. 65% said never or rarely try to change contracts. Breaking that down, as I already shared with you, 71.3% of female versus the 53.4% of male. Is that sort of a socialized, through our socialization, are we more silent as women? Not saying it's true of all women, but there we go. Some people just won't ask out of fear of rejection. This we are breaking down. Now, if you did try, so the individuals, and again, you don't have very many individuals that even try to change contracts from my survey. How successful? 43% said never, rarely. We've got 41% that at least are sometimes, but 16% are just saying no, not at all. Now looking at what types of terms have you been able to change. So now this is when you really sort of break it down in terms of how actually successful these individuals are. And again, these are only the people that even tried, and then when have you been successful? I highlighted the no's. We're more unsuccessful than successful as consumers. And a lot of it is because you have to go, what I'd love to do is really find out exactly how far you have to go to be the squeaky wheel who gets the remedy, because it's becoming harder and harder these days. But now this is interesting, because we played a little game on the survey respondents in the sense that I asked the same essential question, but as a positive and a negative, to see whether you get the same result on whether it's important to read contracts. So when asked, what is your level of agreement with the following statements? And first the statement was, it's very important to read contracts. You've got 79% saying strongly or somewhat agree. When stated another way, and when asked, well, I don't see your level of agreement with, I don't see why I should read contracts, now we're strongly disagreeing, meaning we realize we should read our contracts. 71% strongly or somewhat disagree with the statement that's a waste of time to read contracts. But even if we're aware that it's wise to read the contracts, the level of agreement with assume can't change, 66% strongly agree with that. We're feeling powerless in negotiations. Again, why squeak? Do we rely on our contracts? We already know when it comes to consumer problems and when we have a complaint, no. No. Generally, the answer is not much. How often do you read terms? For the first time only after a complaint arises. We only have 16% that are saying frequently or all the time. Think to yourselves, do you keep copies of all of your contracts and then go back and look at them when you have a product complaint and rely on the terms of your warranty? Probably not. Well, most people don't. Reviewing them, again, same sort of response rate, frequently near the all the time is only 21%. Have we given up on contracting? Should we give up? No, I'm never going to say that. But what do we know right now? In the current state of affairs, we're not reading our contracts for the most part, and that's what the research shows. And really, we're sort of rational actors for doing that because of the time that it would take. Generally not trusting contracts, especially as we looked at how fair you view different contracts. That was true with respect to settlement agreements. Not really caring much about contract terms, especially about things like arbitration, even though maybe we should care. Generally, not squeaking, not negotiating contracts, especially if you're in a group that is feeling disempowered for different reasons. And generally not relying on our contracts as a weapon or using them in order to assert our rights. Feeling pretty bereft with respect to getting remedies. Now, of course, that's not true of all companies. It's not true of all situations, and there are good companies out there. And indeed, some companies are already doing this and providing different sort of remedies to individuals. Well, what we want to do is try to open up access to remedies for all individuals of all socioeconomic status levels to try to build on innovations in the dispute resolution world that are low cost and accessible for everybody, of every race, of every creed, of every economic level. And to create that sense of responsibility. I'm from a small town in the Midwest. And you go out, you purchase something, you look them in the eye, you shake their hand, and you know they're good for it. You go back, if it's a bad product, you don't have to sue. You go back and you say, you know what, you gave me something bad, I want to get a good product, and they'll do that. It's not happening anymore. What we want to do is create what I like to call the new handshake. The new handshake, to use the internet, to use it as a weapon, really, to create these different remedy systems that are low cost, that really let everybody be part of the market. Interestingly enough, you know, this has been around for a while. And actually, the first article I wrote on ODR, online dispute resolution, was years ago. But back then, it wasn't very safe. It wasn't encrypted. There were a lot of problems with it. It wasn't as user-friendly. Everybody didn't have the same technology, and it really wasn't quite as accessible to the whole world. Now, in third world nations, there's a project that I'm working on with the United Nations on a global ODR network. Because individuals in third world nations might not have clean water, but they probably have the internet. Capitalizing on many of the benefits. Now, there are different systems. I'm working with some individuals in California, and we're sort of looking at contextualized processes that you can create that are very much geared toward different disputes. So what I can only share with you today is just to give you a small glimpse of a much larger conversation. But here are just some of the benefits that come with ODR and how we can develop and why it's really fun and exciting. Gets me excited at least. Low cost and user-friendly. It's cheaper for companies and consumers if you can create these different processes. Convenient and flexible. The idea is that a busy mom or somebody, an executive, anybody, it doesn't matter who you are, you would be able to file your claims online and actually get a remedy versus just complaint handling systems that we currently have. But you could go ahead and do that sort of on the hours that work for you. So one person, it might be during the day when their kids are taking a nap, you're working on that. You quick upload whatever documents you need or assert your communications. Versus somebody who wants to do it at night. I mean, we can sort of have asynchronous communications as well as real time. Innovative technologies and techniques. This can really bring everybody into the fold. Think about when you are working on something, I mean, you don't know also what sort of race or status on the other side is. It also can be almost like TurboTax. You can have like guided processes through which a consumer knows what sort of things. You don't have to be the best writer, or to maybe you can use different language software in order to bring everybody in and make it possible for any consumer of any status level from any ethnicity to go ahead and file a claim and to go through this process. What questions to ask, what information to provide in order to be a successful squeaky wheel. Interactive and satisfying. Coming up with different processes where you have a menu, that you as the claimant have a menu from which to choose different processes and the one that suits you best. Types of ODR. Quickly, these are different ones. Problem diagnosis, that's already out there, okay? Complaint handling processes. Think about the Better Business Bureau. They do this for warranty claims on cars, for example. But that doesn't give you, it sort of stops there, right? You file your complaint. I had filed a complaint on something October of last year, and I still have never received a response. It just sort of goes out there into the Ethernet, and people don't follow up on it. So we want to add to that, right? Things like direct negotiation, using Skype, using FaceTime, using all different chat rooms, and there's so many different things you can do in order to have a direct negotiation that's very cheap and easy and not intimidating. Mediation, you might need a third party to come in and to help, and this can be done online. A lot cheaper than having to sort of hire somebody and go to a different location, the travel, childcare, whatever it might be, missing a day of work. This is where, though, this online arbitration comes into play, where you actually get finality. And this is more innovative. This is newer. This is harder to sell. And this is where you get a final and binding decision. Cloud-sourced dispute resolution. Currently happening, for example, on eBay, as you see. A jury of your peers. This is true, and this is in process right now. If you've got a problem with something that's said about your product and you aren't agreeing with it, you can appeal that with your jury. 7 eBay members will then vote on whether that feedback should be taken off of the website because it's inappropriate. So I want to give you, how do we put some of these things together? This is just one example, all right? And kind of bringing in new ideas and new things to just think about. Opening up the discussion, if you will. Think about it. Consumers could go to a central ODR website. So there'd be a central website for consumer products and services under a certain dollar level. This is already happening in Europe under a new directive. They have to do this, and they're creating this right now. So it's time for us to sort of get on board and open up access to these consumer remedies. You go to a central ODR website, and let's say then there's a trust mark, kind of like the Better Business Bureau has a trust mark. So all the merchants that opt into this get to post that on their site and get the goodwill of having that on their website. That would link a consumer. So if you have a problem, you would know that that trust mark means that if you have a product complaint or a service complaint with that merchant, that you could then go to that central website and choose your process. Merchants would have to also, and this is what's new, is putting skin in the game, deposit some funds. And of course, you got to get the buy-in of the company. But think about it this way. Companies are going to benefit as well from the goodwill that you get from the trust mark. There's a reason why companies pay the fees to be part of the Better Business Bureau. Also, it's a lot cheaper than having a class action filed against you. This is how simple it is. The buyer reports the issue. Merchant responds. Buyer chooses. That's how easy it is. The seller, maybe the seller will garner goodwill and avoid further costs of any sort of litigation just by going ahead and providing a remedy. But think, as a consumer, if you feel that empowerment, if it's easy like that, if it's centralized, if it's linked with a trust mark, in order to earn that trust mark, they would have to abide by due process standards. It would be fully encrypted. It'd be safe. You'd know it's the real deal and not some fake or a scam. This could be very empowering for us as consumers and also companies. Because again, there's a lot of good companies out there that want to know. I mean, the literature shows also that they do want to actually know about product and service complaints. Many companies then can improve, and they'd rather find out about it earlier rather than later when there's a class action against them or something like that. Online mediation. You might need to go that next step. Companies and consumers often want to be heard. Things aren't all very clear in terms of who's right and who's wrong. This is new, adding the endpoint and actually having a final and binding decision. And because of the deposit of funds that the companies have put in place, you actually will be able to get a remedy more quickly because there's some money there, you know that there's collateral, more or less. Trigger mechanism. The trigger mechanism is something that regulators are pretty excited about to help them out. The idea being that on this centralized website, when a certain number of complaints are launched against that exact same product, a red flag would go up, and they would know, well, this might be a problem. Now, I'm fully aware you're not going to get all companies to want to buy into this, right? I mean, if I'm thinking as an executive, why would I want to open myself up to this trigger mechanism that could get me in trouble with regulators? Well, it might actually be to your benefit because then you could ward off, you could deal with it right away instead of having further action against you or whatever it might be. But also, sometimes if it has to do with health or safety or something along those lines, then it's like too bad, right? We really need to do something about it. But no matter what, I'm just opening up discussions and ideas, and this is all sort of, growing. And we have to think about key considerations and how it's crafted. Because like I said, there are certain dispute programs out there online, but they haven't been done well. We need to do a better job. Clear contract notice. Right now, for example, Facebook for many years had an online dispute resolution system for privacy claims. The problem is that nobody knew about it. I did an unscientific poll of my students all on Facebook, and they had no idea that this existed. Accessible guides and demos. Right now, when you don't know that these things exist and you're not provided any sort of demonstration or just an easy way or something you can just click real quickly and just see what it's all about. So it seems intimidating and scary. But if there's these accessible guides showing individuals of all status levels, education levels, how it works, then it makes you feel more comfortable and almost seems like it could be fun. I mean, Professor Gazer knows this, I hate taxes, all right, or having to file any sort of taxes. But I love TurboTax. I swear, to me, I'm not intimidated by it anymore because it guides me through the process. Free, low cost to consumers. This is so important. The problem with arbitration and the biggest complaint is that the startup costs are high for a consumer, especially if it's a low dollar claim. But an important case that came from the United States Supreme Court just very recently, AT&T versus Concepcion, says that's okay. Those arbitration clauses are still enforceable even if they're going to cut off your rights as a consumer to a class action, and even if it's a lower dollar claim. Because those costs could then be sort of allocated in the award, or you could show sufficient hardship. Think about it. That makes it awfully difficult because you still have the startup costs of the filing fee. But with online dispute resolution, you can do it quite cheap and easy. Timely decisions, which I'm not timely and I'm going over, so I better get going. But timely decisions, we can put time limits on these different claim processes. And it's going to be a lot faster than any sort of face-to-face dispute resolution process when you can do it online. Again, because of the flexibility. Award compliance. This is where the deposit of funds becomes important. Education and awareness initiatives, a central website. Right now, we kind of have to look around and see somewhere in the fine print of a Facebook terms whether or not we might have a right to ODR. The trust mark, so you know it's the real deal. That there's an actual, you went through due process standards, that those that are actually the online arbitrators have had some training and know what they're doing. The trigger mechanism, especially when it comes to issues having to do with health and safety. Bottom line is we want to seek solutions and not give up. We as consumers really can be empowered, and I know I get so excited about this because I think we always have to be willing to try and find solutions to open up the way that we can all get help on our complaints. I know how frustrated I have been with respect to consumer contracting. Is it getting worse? Yes. Am I worried about these secret consumer scores? Yes. And different people getting offered different deals? Yes. Right now, there's actually a lawsuit against a cell phone provider that went into arbitration, so it's been ordered. So many of you probably don't know about it, which is squelching the informed consumers. Here's what it is. The cell phone provider was offering different deals to different consumers, which was fraud, is fraud. but because nobody knew about it unless you called up. It was the squeaky wheels who were getting the better prices. We want to address that contract discrimination, address the market failure, help the market do its job. Aiding access to remedies for all individuals of all status levels. Enhancing enforcement of consumer protection laws, even in this age where class actions are so cabined and where arbitration clauses have become the norm. Efficiency and fairness. This really can be good for companies and consumers. And yes, it is a tough road and it's hard to sell this. But you know what? Once it's sold, it goes very far. Look at Europe. Look at the rest of the world. Others are getting on board, and we should too. Thank you. And for further, lots of other work on this is sort of posted elsewhere. But most importantly, I guess I want to open it up to questions that you might have. And certainly, if you've got more ideas, and I have my pen and paper in hand. So I don't know if you had anything you wanted to say? Chris, yeah.
Thank you for that talk. I learned a lot, especially some of your ideas about. I just wondered, do you have any examples of where you have one pie chart that said, the bar chart, that said consumers have had a higher level of success negotiating arbitration clauses under them, and in many other areas, potentially going to get into like that arbitration. Where does this happen?
Actually, I was highlighting the nose, and I probably misspoke then when I did that because it was the nose. So it was, yeah. And that's, I'm sure, and if we go back, yeah, thank you for that. And I'll do it quickly, but let's go there again because, yeah, and then I can answer your question because actually it got the lowest, it was low. This is the backward version, like when you're walking backwards. We used to do that to my poor grandma. We had this video where we'd show her going backward and forward. Oh, so this is highlighting actually no. So the purple is the no, where they weren't successful. Yeah, so I was highlighting the...
So you almost never can get rid of them.
Exactly.
Are they always enforceable, or do they sometimes get struck down?
You know, yeah, it's actually, it's astounding. Because, and thank you, because that's a whole other area of my research that it's astounding, and different amicus that we've worked on in the United States Supreme Court that seems so clear. How can that be enforceable, right? But it is, even when it deals with a consumer protection law, and there was a recent case actually where the court said, no, it can still be enforceable. You agreed to it, you're the rational contractor, right? They're actually extremely, and what's interesting to me is that teaching arbitration is that when I first started teaching arbitration, we didn't ever expect those things to be enforceable. I mean, really, we just didn't, and now they're just all enforceable. It's like bulletproof. You know which way the Supreme Court's going to go when it comes to enforcement of arbitration clauses. Thank you. Good question. I don't know. I mean, yeah, it's unless something changes, it doesn't look like it's going to change. So, yeah, I don't know. I mean, I'm sort of surprised. Just to reveal, the truth is I've lost. I mean, I've been on the losing side in my amicus, so I can't say that. No, I don't know. Yes, sir.
How do you negotiate a contract in the future? By definition, you can't. So, I mean, all these consumer contracts are contracts in the future. How do you even get to that threshold of negotiation?
Yeah. And thank you, because I've had you teach my classes, so thank you very much. But yes, you know, you can once in a while. I do my own little sort of unscientific research, and I've been able to change form parents sometimes. But you're right, oftentimes it's nearly impossible. So again, it does support why consumers aren't going out there and trying to negotiate those contracts. Yes?
What are the problems you identified with this? But ODR would also, put ODR all address that.
Yeah, and that's something that we're struggling with and trying to figure out the best way to do that. And a couple of things. Number one, making it extremely low cost and less intimidating. And number two, you're less worried about sort of that stereotype threat. Because there's this interesting research that's showing that if you become sort of disempowered and you're worried about complaining, or if you're not as good with the English language or whatever it might be, you're less likely to do the face-to-face, but online can be less intimidating. And so you might, more so than you'd expect. No, that's a really good point, and that used to be a real problem with online dispute resolution. But now, as it turns out, it's actually, people of all economic levels and of all backgrounds have access to the internet. And what they actually show, and that's such a great point, because yeah, I worry about that, and I did worry about that. Those who actually I worry about the most when it comes to ODR having access is the older you are. Because really it's more age than it is economics. But yeah, that's a struggle, and that's part of the new handshake, and the thing that we're trying to work on is trying to figure that out and keep it as low cost as possible and unintimidating and guided as possible to bring everybody into the fold. But that's a super good point. Yes, sir.
I'll bring up an example. One of the companies I have the most complaint about, Comcast. Say the same thing. Now, what Comcast does, what many companies in the service area, is that the squeaky wheel will get every 6 months. I've got to follow up and say, I'm quitting, I'm leaving, and they will say, no, wait, and then they will give me a discount. And I always ask the question, if I hadn't come in here, and they said, they don't answer that. Now, that's the way many companies operate. Okay, so what legal remedy do we have as consumers to make sure that a company like this is offering a fair and consistent rate to everybody? There is no legal remedy.
Well, it's a tough one. And let me tell you, that lawsuit that I mentioned at the end there actually has to do with something. This is a great question, because it's a tough one, is the answer. Because first of all, on the one side, you can say it's benign business, and that if, you can actually, you are completely, it's kind of the Wild West. A lot of the rules and the laws that we have in place in other areas, like with housing or what, it's not the same when it comes to consumer contracting. And so your question is it's tough to answer, and I wish I knew, because this lawsuit that's going on, what they're doing is they're claiming under a state consumer protection law that it was fraudulent for this company to be doing this, just what you're talking about. But then again, you can say, well, it's rationing appropriately to the most lucrative customers, and we have a choice. We want to retain loyalty rewards, and there are different reasons why. Right now it's under TRO, it's temporarily stopped in its tracks. It's sent to arbitration. There can't be a class action on it. It's actually completely and totally stalled right now, the case is. So, it's a tough one. I mean, you can try to claim fraud or a price fraud or different things like that. I mean, there are a lot of different claims that probably, could be crafted, but it's tough, and it's a good point.
But you would think I don't know who's the governing body, Public Service Commission, I don't know what it's called in Colorado, you would think they obviously aware, and that they would try to
Yeah, I mean, I have to tell you, I filed that complaint with a different regulatory agency last October, and I still have not even received a reply. Yes, sir.
This Comcast case, is it fraud if they equally discount or give you that special offer for 6 months to everybody, but you have to ask the question?
No, probably not.
If you don't ask that question, then you don't offer that, but we'll give it anyway.
I don't think so, but you know, it would depend on, I mean, I don't know.
So they're giving a price different to other customers,
Right.
but they will give you that discount equally if you say I'm leaving.
In,
Anybody that says we're leaving, we're going to give it to you. You have to know to ask that.
and I would ask also, I mean, if you have to ask in order to find out what you're saying is having to go, I think what you're asking, I want to be sure I understand, is if you have to go that extra mile, if you have to ask in order to get the remedy, just that difference, does that make it fraudulent?
But because he said, I'm leaving and going to, oh, well, in that case,
It's probably not fraudulent.
I would have got the same deal, but I didn't ask that question. So that if you get to that point, you're saying, I'm leaving and going somewhere else, then they'll give you that discount equal. That makes it fraudulent.
I would guess, and I don't know, again, I'd have to really look at it, I would guess no unless. Here's what I'm thinking, and this is what's happening in this other lawsuit and what makes them sort of more in peril, is that this company also was using in their advertisement for new customers and saying that their price was this lower, better price. So they were benefiting, so it was price discrimination in the advertisement itself. So that would be my key consideration. Simply asking, I'm guessing no.
One final question.
Peppet, Mr. Peppet. And I shouldn't have asked the contracts professor. I'm going to get like the scariest. Well, I mean, they're not really offering, anybody can, we're all aware, at least, of the loyalty program. I mean, they're sort of, the terms are what they are. It's the ad hoc, yeah, it's the secret aspect. You know, the fact that you've got to squeak in order to get this better deal. I mean, it was $30 difference per month, for example, in this lawsuit that I'm mentioning, you know. And I know the attorney who's asserting this claim, and he, just the system's broken. I mean, how do you get this to go forward? How do you do anything and get the word out? But your question is really good for this reason, and I know we're short of time, but it also brings in this new, putting it together with the squeaky wheel system and those loyalty cards. See, they're getting an awful lot out of that loyalty card from you in terms of big data. And that is going into your consumer score, along with your zip code, your nationality, and there's number crunchers out there that are creating your consumer score. And you might be routed to a different customer service representative who's offering the better deals because you have a good consumer score. But it's not under the Fair Credit Reporting Act right now. To you guys. I'm clapping to you all as consumers.
So we now have a reception. Please come join us and congratulate Amy. Really wonderful.
But as you leave, and because it was mentioned, and for your listening enjoyment, the song I wrote. cue the song so we can all be in consumer protest together.
I'm doing my very best.
Enjoy the reception.
But all these confusing contracts have put my sanity to the test.